My lady may kindly come to the main petition now at page 30. 30. Huh? 30. 32.
32.
This is, the FIR is 32. This is dated 9/3/2003, 2023. 9/3/2023.
2023.
And this has been filed by the Director, Nagaland State Lotteries. May I read this? This is which has been under challenge and the proceedings initiated pursuant to this. This was filed before the North Police Station, Kohima.
Yes,
May
please
I
read.
read this? Request for initiating necessary action FIR against those persons involved in the sale of illegal fake paper online lottery tickets in various parts of West Bengal using the name and logo of the Nagaland State Lotteries. Sir, my lady may I pose. The investigation is not just relating to that particular jurisdiction of Harihari Street, as we have seen, as we have read, the police, but it's regarding sale in West Bengal, in the entire state of West Bengal. With reference to the government letter number such, 1/3/2023, on the subject cited above, I am state that the under mentioned 4 persons mentioned as serial number 4 are reported to be indulging in the printing, circulating of fake lotteries in the state of West Bengal, tarnishing the image of the state. The government of Nagaland is organizing and conducting lotteries as per Lotteries Regulation Act 1998 and the Lotteries Regulation Rules 2010, as well as the rules of the Nagaland government and instructions issued by the Ministry of Home Affairs from time to time. The lotteries conducted by the state of Nagaland are in strict compliance with the provisions of the Act and rules which are marketed in 5 states where West Bengal is one of the biggest. My lady, apparently there's no ban of paper lottery sale in the state of West Bengal except for that online. That Gazette bans online lottery.
Yes.
To conduct smooth marketing of Nagaland State Lotteries tickets in the state of West Bengal, Government of Nagaland have appointed distributors. Inter alia, the distributors have appointed sub-distributors, and the sub-distributors have appointed area distributors, and the distributors thereafter have appointed stockists, sub-stockists, retailers, etc. Recently, several complaints have been received from Nodal Officer Directorate of Nagaland State Lottery Scam, Kolkata, and area distributor, agents, stockists, sub-stockists, etc. That some persons are indulging in circulation and selling of illegal fake paper lottery tickets, which flourish in various parts of West Bengal, resembling the name logo of the Nagaland State Lotteries. From the complaints received by this office from the various stated stockists, sub-stockists in the state of West Bengal, we have come across some common names who are involved in the printing and circulating fake lottery tickets in the state of West Bengal. Then only 3 petitioners are named here. Number C is not a petitioner hearing. Detailed list of persons and activities involved is also annexed herewith for your ready references. These people are also trying to malign the reputation of Nagaland Lotteries by duplicating and using the name and logo of the Nagaland State Lotteries in the fake and fabricated lottery tickets. Pawan Jumjumala is also involved in printing, he's not a petitioner in this case, circulating the fake lottery tickets in the state of Jharkhand and Bihar, and various cases are registered in this regards in the name of different police stations. Atul Bokaria also regularly files RTI application to the department and tries to get confidential documents from the department, and also file a complaint before the Enforcement Directorate to malign the image of Nagaland State Lotteries, and he has attached the agreement copies between the government of Nagaland and the distributor, which is confidential and is not even shared to Atul Bokaria even after his repeated RTI applications. I further in the same complaint to the Enforcement Directorate, the said Atul Bokaria has attached a confidential letter dated is never been disclosed to public. He is maligning the image and reputation of the Nagaland state lotteries and has procured the documents by illegal means and is purposely sharing the same in open market. The wrongful of these persons are also published in newspapers and news portals, which are also enclosed here for your kind perusal. An FIR is already registered against the state of West Bengal. My lord, here also, my lady, they have also mentioned that the FIR is registered. Further, the accused above named persons are also engaged in producing, manufacturing fake prize-winning lottery tickets after dealing with the same from the result published in Nagaland state lotteries. These persons then release such fake prize-winning lottery tickets into the market and encourage them with the retailers, and ultimately the retailers of the lottery tickets get duped from such activities. Furthermore, the state of West Bengal leaves rupees 3 lakhs per weekly draw and 10 lakhs per bumper draw sale of other state lotteries. Knowing well of these facts, the persons involved in the printing and circulating of fake lottery tickets are evading such draw charges to the state of West Bengal. Further, from the date of inception of GST in India, the sale of lottery tickets attracts 28% GST, and it can be evident from the act of the accused person that they also defrauded the respective state and central government for a huge sum of money concerning non-payment of GST, and also have defrauded government from other related taxes or gross charges as applicable. To be more precise, the accused persons are conducting business of printing and selling fake lottery tickets in the state of West Bengal without paying any statutory taxes. Further, it is learned from different sources that the above named persons are further involved in conducting, organizing illegal online lotteries by various previous means, and most illegally run the same in the state of West Bengal, being fully aware of the fact that by the date of Kolkata Gazette Extraordinary Notification Number Such dated 21/5/2013, the state of West Bengal has banned the sale and marketing of online lottery tickets in the state of West Bengal. In the light of the officer's circumstances, we hereby request your good office to kindly take necessary actions against the perpetrators for the offences of 1. A. Dealing and selling illegal paper lotteries in various parts of West Bengal. B. Cheating public by illegally conducting online lotteries using personal computers, machines not connected to central server. C. Misuse of Nagaland state logo and theft of important official documents pertaining to Nagaland state lotteries, which were furnished to Atul Pokhariya in the RDI replies. And listing is action will protect the innocent common citizen from fraud and also save the numerous honest people who are associated with legal paper lottery business and are doing business sincerely to earn a livelihood to support their families. It is therefore requested to take stern action against the offenders by initiating appropriate legal proceedings, including the registration of first information report, and prosecute them for commission of various offences as required under law against the culprits, so that such instances should not happen in future. The same will not only safeguard the image and reputation of the Nagaland state lotteries, but will also protect the innocent populace from this fraud and will safeguard the revenue of the state of West Bengal and central government. So basically, same allegation. In fact, the word are also, certain words have been taken out from the first FIR. Very similar words, similar languages, similar sentences have been used. Allegation is the same. Fake lottery tickets of the state of Nagaland being sold in West Bengal, printing of fake winning lotteries, and also online, Nagaland online lotteries. And also,
one difference is that misuse of the Nagaland state logo and theft of important documents.
they're saying theft. So, my lady, theft.
Theft of
Theft of some
official
important
documents.
confidential documents.
Which were furnished to such
Regarding the logo, my lady, regarding the logo, that is printed in the lottery ticket system. So that will be again covered by the first FIR. Because they're saying using the logo, state logo, Nagaland lotteries. So the state logo is there in the Nagaland state lottery. So that is part of selling of the fake lottery tickets. Now the only thing is regarding stealing or theft of documents. Now, therefore, it is important to see that, of course, my lady, initially the offences under which this was registered, may I just read out the sections. which is mentioned at page 30. If your lady mechanic take a note of this, I'll just mention it. I'll read it out. Initially, it was 120B, 417, 464, 465, 499 IPC. Subsequently, more sections were added, 34, 420,
34, 420,
500, 467, 468, all IPC.
IPC.
Then Lotteries Regulation Act 1998, Lotteries Regulation Act 1998, Section 7, bracket 3. These were subsequently added. Now, my lady, during the pendency of this petition, charge sheet was filed. So therefore, we have filed an affidavit bringing the charge sheet. That was an affidavit filed on 14 November.
So finally, in the charge sheet, what were the sections?
Yes.
This 34.
That is very important.
420.
Theft is not there. They said we have taken documents through RTI only. My lady mechanic come to the sections mentioned in
page
the
9.
page 10. It's just the sections only. Page 10. I'll read the entire chart sheet. 10. Section 120B. Section 417, 420, 468, 64, 465, 467, 468, 499, 500, read with section 34 IPC, then
7.3 lottery 7.
Theft is 378, I think. This is not there.
Okay.
My lady, I have just skipped. My lady mechanic, I'm sorry, mechanic could go back to the affidavit that was written.
Which
earlier.
one? The additional affidavit
Additional
or the affidavit?
One, no, not the additional affidavit, the main petition, page 30. I have to show this also. Page 34. List of persons involved in the theft. They have also given a list, page 34, along with an FIR.
Yes,
Along
list
with
of
that,
persons.
My lady, serial number 2 is also a petitioner. Serial number 3 is also a petitioner. Serial number 4.
Not 3.
3, not 3, 2.
1,
2, 4,
2, 4,
5,
5,
6, 7, and 20. 20. Raman is not there, no? I have to point out, my lady, in that Kolkata FIR, this number 20, petitioner number 6, his name has not been mentioned in that case. In the Kolkata Harris Street. Case. Just pointing it out.
petitioner number 6 is not there
It's not there.
in the Kolkata case.
Yes, in the Kolkata case, Harris Street case. My lady, may I read the charge sheet now? Affidavit, the second affidavit. My lady, this was filed on 14 November 2025, charge sheet. Then also subsequently, again, supplementary charge sheet, but I'll read the entire thing. May I read this? The instant case was registered at North Police Station, Kohima, by case number such, that is such, under section such, based on a written complaint by so-and-so, Director, Nagaland State Lotteries, Kohima. Allegations in the FIR. As per the FIR lodged by Sri Nagaland State Lotteries, the allegations are as follows. Printing and circulating of fake lottery tickets in the State of West Bengal, cheating public by illegally conducting online lottery draws using personal computer machines not connected to the central server, misuse of official Nagaland state logo, theft and misuse of important official documents of the Nagaland state lotteries were furnished to Sri Atul Bukharia in response to RTI application. The complainant has also listed certain names alleged to be involved in printing of fake lotteries. The names are given. As per the direction of such and such, order number such, dated such, a special investigation team was considered comprising so-and-so. 2, the team led by so-and-so, not police Kohima, along with UPSI so-and-so, and so-and-so, proceeded to Kolkata on 22/7/2023 for investigation. Notices were served under Section 160 CRPC to individuals who had reasonable grounds for questioning. The team inspected godowns where tickets were stored and verified the process of receipt and dispatch. Voluntarily admitted to filing multiple RTI applications and complaints addressed to various authorities, including the Honorable Prime Minister's Office, Ministry of Home Affairs, and Enforcement Directorate. Accountant admitted drafting of letters, complaints for Atul Bukharia, but denied involvement in fake lotteries. Rahul Mishra Bhotra, photographer from Pune, denied allegations. Mahendra Bukharia denied allegations, claimed to be a social worker and share market businessman. Avinash Chotia denied allegations, stated to be a social worker. Pawan Kumar Chumla, proprietor of Ganesh Pepper Mart, Bihar, denied allegations. Documentary evidence. 11 documents were obtained under Section 91 CRPC from the Directorate of the State Lotteries, including complaint letters written by Atul Bukharia. Additional sections. Initially, the case was registered and such. However, further investigation repair was made before the Honorable Court for inclusion of additional sections. On so, the court granted inclusion of the following sections. Conclusion and finding. From the above investigation, the following facts have been established. The fake paper lottery tickets bearing the name and logo of Nagaland State Lotteries were printed, circulated, and sold in the state of West Bengal, thereby cheating the public at large. 2, that the confidential and official documents of Nagaland State Lotteries obtained through RTI, my lady may kindly note, 2, obtained through RTI, not question of stealing here, obtained through RTI, were misused by Atul Bukharia and associates for filing of frivolous complaints and representation before various authorities with the intent to defame and malign the department. So allegation minor has not been narrowed down now. We have obtained it through RTI and used these documents to make complaints to competent authorities, making false and frivolous allegations and thereby defaming the state of Nagaland. So it's defamation now, confined to defamation only. The names of
no, but the fake paper lotteries,
yes,
using the name and logo without permission.
That is selling of fake lottery tickets, man.
Using the logo without
yes,
permission.
using the, because the lottery logo of the state of Nagaland is printed in the lottery ticket.
But not anybody can just use it
No,
like
no,
that.
definitely not. So therefore, my lord, selling, this also amounts
So
to selling
Nagaland
of...
government also has a grievance. Anyway, yes,
Yes.
continue.
So these are, now, the name of the following individuals has surfaced repeatedly during the course of the investigation are being directly or indirectly involved. We have not been charge sheeted. We have not in this case.
Where are the names? Parties of accused?
Not charge sheeted, my lady.
Oh, para 13.
Para 13,
in
yes.
the
In the
type
column,
copy,
in the column,
107, column 13.
Yes. Column 3. Names are given. Name will be there.
So where are your names?
Lady,
Serial number?
number 4, my lady. Number 4. Number 4, 5. Number 6. Number 6. There's 2 number 6. Number 6. Then number 7. And number 8.
Number 7, number 8.
As you don't have the facts, no? I'm ready already.
Okay.
So, my lady, these are the facts. Now, to support this, whether these allegations are same or not, and if the allegations are same, and how do we look into what similarity has to be there, may I just now straight away go to the authorities. My lady, for the sake of convenience.
Who has supplied this? You have supplied. Criminal petition, such and such, first FIR, second FIR.
My lady, that was filed earlier by, most probably before I entered, my lady. I entered subsequently. This was filed sometimes.
Yes.
So maybe I'll not be referring to that. Everything has been brought on record through the affidavit, all relevant materials. My lady, here I've just prepared a list of authorities for the sake of convenience. And also be supplying. First, take out the books. Oh, that one. Take out the books, please. Give me the books. 2006, 2001. 2001. 2001. 2001. Kagan asirang ako ba? Kakachitama ko. Nay mali. Yate supply ko yung convene. My lady, the P.T. Anthony case,
Yes.
which has been followed till today and referred and relied upon in many cases. This is the. My lady, may I just go to the relevant paragraphs? Yes. This is also regarding filing of similar incident taking place at various places. At 2 places.
Para.
Yes, my lord. Lady, I'll read 18, 19, 20, 27, and 35.
20.
19, my lady, I have written in the list of
18,
authorities already. 18, 19, 20,
20,
27, and 25.
27 and 20, 25.
And I'll be highlighting on 20, 27, and 35. 18. In information given under subsection 1, section 154 CRPC is commonly known as the first information report. Through this term, it is now used, though this term is not used in the code. It's a very important document. And it, as its nickname suggests, it's the earliest and the first information of the cognizable offences recorded by an officer in charge of a police station. It sets the criminal law in motion and marks the commencement of investigation, which ends up with the formation of opinion under section 1969 or 170 CRPC. As the case may be, the forwarding of a police report under section 173 CRPC. It is quite possible, and it happens not infrequently, that more information than one are given to the police officer in charge of a police station in respect of the incident involving one or more cognizable offences. In such a case, he need not enter every one of them in the station house diary, and this is implied in section 154. Apart from vague information by phone call or cryptic telegram, the information first entered in the station house diary, kept for this purpose by a police officer in charge of a police station, is a first information report, FIR postulated by section 154 CRPC. All other information made orally or in writing after the commencement of the investigation into cognizable offences disclosed from the facts mentioned in the first information report and entered in the station house diary by the police officer or such other cognizable offences as may come to his notice during the investigation will be statements falling under section 162. No such information statement can properly be treated as an FIR and entered in the station house diary, as it could in fact be a second FIR, and the same cannot be in conformity with the scheme of CRPC. Take a case where the FIR mentions cognizable offense under section 307 or 326 IPC, and the investigating agency learns during the investigation or receives fresh information that the victim died. No fresh FIR under section 302 needs to be registered, which will be irregular. In such a case, alteration of the provision of law in the first FIR is the proper process to adopt. Let us consider a different situation in which H, having killed W, his wife, informs the police that she is killed by an unknown person, or knowing that W is killed by his mother or sister. H owns up the responsibility during the investigation. The truth is detected. It does not require filing of fresh FIR against H, the real offender, who can be arraigned in the report under section 173.2 or 173.8 CRPC, as the case may be. It is the cause permissible for investigation officer to send up a report to the magistrate concerned even earlier than the investigation is being directed against the person suspected to be accused. 19, my lady. The scheme of CRPC is that an officer in charge of a police station has to commence the investigation as provided under section 156 or 57 CRPC on the basis of entry for the first information report on coming to know of commission of cognizable offences. On completion of investigation and on the basis of evidence collected, he has to form an opinion under Section 169 or 170 CRPC, as the case may be, and forward this report to the magistrate concerned under Section 173(2) CRPC. However, even after filing such report, if he comes into possession of further information on material, he needs not register a fresh FIR. He is empowered to make further investigation, normally with the leave of the court, and where during further investigation he collects further evidence, oral or documentary, he is obliged to forward the same with one or the other further reports. In this is import of the subsection 8 of Section 173 CRPC. 20, my lady, this is important. From the above discussion, it follows that under the scheme of provision of Section 154, 55, 56, 157, 162, 169, and 170 and 173, only the earliest or the first information in regards to the commission of cognizable offence satisfies the requirement of Section 154 CRPC. Thus, there can be no second FIR, and consequently, there can be no fresh investigation on receipt of every subsequent information in respect of the same cognizable offence or the same occurrence or incident giving rise to one or more cognizable offences. On receipt of information about a cognizable offence or an incident giving rise to a cognizable offence or offences, and on entering the FIR in the station house diary, the officer in charge of the police station has to investigate not merely the cognizable offences reported in the FIR, but also other connected offences found to have been committed in the course of the same transaction or the same occurrence, and file one or more reports as provided under Section 173 CRPC. My lady, may kindly come to paragraph 27, page 200. A just balance between fundamental rights of the citizens under Article 19 and 21 of the Constitution and the expressive power of police to investigate a cognizable offence has to be struck by the court. There cannot be any controversy that subsection 8 of Section 173 CRPC empowers the police to make further investigation, obtain further evidence, both oral and documentary, and forward a further report or reports to the magistrate. In another case, it was, however, observed that it could be appropriate to conduct further investigation with the permission of the court. However, the sweeping powers of the investigation does not warrant subjecting a citizen each time to fresh investigation by the police in respect of the same incident giving rise to one or more cognizable offences. Consequently, upon filing of successive FIR, whether before or after filing of the final report under section such and such, it could clearly be beyond the purview of Section 154 and 156 CRPC, nay, a case of abuse of statutory powers of investigation in a given case. In our view, a case of fresh investigation based on second or successive FIR not being a counter case. My lord, a counter case FIR can be a second FIR in the same filed by the opposite party. Filed in connection with the same or connected cognizable offences alleged to have been committed in the course of the same transaction in respect of which, pursuant to first FIR, either investigation is underway or final report under Section 173 has been forwarded to the magistrate, may be a fit case for exercise of power under Section 482 CRPC or Article 226, 227 of the Constitution. My lady, may kindly come to paragraph 35 now. Page 204. For the aforementioned reasons, the registration of second FIR under Section 154 on the basis of letter of the Director General of Police as crime is not valid, and consequently the investigation made pursuant thereto is of no legal consequence. We accordingly we hasten to add that this does not preclude the investigation agency from seeking the leave of the court in crime number such for making further investigation and filing a further report or report under section such and such before the competent magistrate in the said case. In this view of the matter, we are not inclined to interfere with the judgment of the High Court. So, my lady. So, here, my lady, this clearly says there may be certain more allegations regarding the same transaction, but the transaction incident or occurrence is the same. There may be so many angles involved in it, but that has to be dealt with the first FIR only. And if anybody makes further complaints, that will be in that first FIR, and it will be those statements will come within the purview of 162, not 154. My lady, Arnab Goswami, let's go to the next. Arnab Goswami, please. 2020. 2020. Well, this is a case where not only in the state of Maharashtra, but in various across the country, numerous multiple FIR were filed regarding the same incident, same allegation. Now, my lady married from paragraph 30 onwards. As I go, I'll mention the paragraphs, my lady. I've already marked it out there. I'll start from paragraph 30, page 36. I miss out. Page 36.
Yes, analysis.
Analysis. The fundamental basis on which the jurisdiction of this court has been invoked under Article 32 is filing of multiple FIRs and complaints in various states arising from the same cause of action. The cause of action was founded on a program which was telecast on our Bharat on such site. FIRs and criminal complaints were lodged against the petitioner in the state of Maharashtra, Rajasthan, Telangana, Jharkhand, etc. The law concerning multiple criminal proceedings on the same cause of action has been analyzed in judgment of this court in TT Anthony case, the one which we just read. Speaking for the two judges bench, such Syed so-and-so justice, interpreted the provision of 154 and cognate provisions of so-and-so. We can skip this, my lady. We can go to paragraph 31. The court held that there can be no second FIR where information concerns the same cognizable offense alleged in the first FIR or the same occurrence or incident which give rise to one or more cognizable offense. My lady, this is what I'm trying to impress upon the honorable court, that it is the offenses are same, it arises from the same incident. This is due to the fact that the investigation covers within its ambit not just alleged cognizable offenses, but also other connected offenses that may be found to have been committed. So, my lady, if it's a logo, yes, connected with the offenses alleged in the FIR, then yes, my lord, it becomes part of it. This court held that once an FIR postulated by the provision of Section 154 has been recorded, any information received after the commencement of the investigation cannot form the basis of the second FIR, as doing so will fail to comport with the scheme of CRPC. This court observed. My lady, can skip this again, 32 again, my lord. This court averted to the need to strike a just balance between fundamental rights of the citizen under Article 19 and 21 and expansive power of the police to investigate, averting to the precedent. This court held, we have read this, my lord, paragraphs 27, 33 now, paragraph 33. The court held that barring situation in which a counter case is filed, a fresh investigation or second FIR on the basis of same or connected cognizable offences could consider the abuse of the statutory power of investigation and may be a fit case for exercise of powers under either article under section 482 CRPC or article 226 of 227 of the Constitution. And my lady, 34. The decision in TT Attorneys came for consideration before three judges bench. Speaking for this court, averted to the earlier decision of this court in such and such, then the court of caution. Of course, the legal position is that there cannot be two FIRs against the same accused in respect of the same case, but where there are rival versions in respect of the same episode that could normally take the shape of two different FIRs, and investigation can be carried out on the board of them by using the same investigation agency. My lady, so that is not the case. I file an FIR alleging about something of some person, and that person also files a counter FIR. So that becomes two different FIRs, which is permissible. And my lady, 37. In the present case, all FIR or complaints which have been lodged in diverse jurisdiction arises out of one and the same incident, the broadcast by petitioner on such and such on our Bharat. The broadcast is the foundation of the allegation that offences have been committed under such and such. During the course of the hearing, this court had the occasion with the assistance of the learned senior counsel to peruse the several complaints that were filed in relation to the incident. They are worded in identical terms and leave no manner of doubt that an identity of cause of action underlies the allegation leveled against the petitioner on the basis of the program which was broadcast on such and such. Moreover, the language, content, and sequencing of paragraphs in the numbering is identical. It was in this backdrop that Mr. Kippel's so-and-so fairly submitted that this court may proceed to quash all the other FIRs complaints lodged in diverse jurisdictions in the state, leaving open how the investigation in respect of such and such transferred from Police Station Sada, District Nagpur, to NM Joshi, Police Station. My lady, this is the first FIR. This was initially filed in Nagpur, then transferred to Mumbai. Then 40 months. The issue concerning registration of numerous FIR and complaints covering different states, however, as we will explain, distinct from the investigation which arises from in FIR number such and such at M. Joshi Marg Police Station in Mumbai. The petitioner in excess of his right under Article 19A is not immune for investigation into FIR which has been transferred from Police Station Sadar Nagpur to Joshi Police Station Mumbai. The balance has to be drawn between the exercise of fundamental rights under 19(1)A, investigation of offences under CRPC. All FIRs in respect of the same incident consider a clear episode of process and must be quashed. My lady, we have in that Kolkata case, my lady, we have not sought for quashing. We are willing to undergo trial, but for the same allegations, can I be prosecuted again somewhere elsewhere? Then, my lady, 53. A final aspect, 53. A final aspect requires elaboration. Section, my lady, this is very important. Section 199 CRPC stipulates prosecution for defamation. Subsection 1 of Section 199 stipulates that no court shall take cognizance of an offence punishable under Chapter 21 of the Penal Code, except upon a complaint made by some aggrieved person by the offence. However, where such person is under the age of censor, mental illness or sickness or infirmity rendering the person unable to make a complaint, or is a woman who, according to local customs, manners, ought not to be compelled to appear in public, some other persons may, with the leave of the court, make a complaint or his or her behalf. Subsection 2 states that when the offence is alleged against a person who is the president or the vice president, governor of the state, administrator, so, or any public servant employed in connection with the affairs of the union or the state in respect of their conduct in discharge of the public function, a court of session may take cognizance of such offence without being committed to it, upon a complaint in writing made by the public prosecutor. Subsection 3 states that every complaint referred to in subsection 2 shall be set forth facts which constitute the offence alleged, the nature of such offences, and such other particulars are reasonably sufficient to give notice to the accused of the offence alleged to have been committed. Subsection 4 maintains that no complainant under subsection 2 shall be made by the public prosecutor except with the previous sanction of the state government in case of no person who is or has been the governor of the state or minister of the government or any public servant employed in the connection with the affairs of the state or the central government in any other case. Subsection 5 of the bars this court of section from taking cognizance of an offence under subsection 2 unless the complaint is made within 6 months from the date on which the alleged offence is made. Subsection 6 states that nothing in this section shall affect the right of the person against whom offence is alleged to have been committed to make a complaint in respect of the offence before a magistrate having jurisdiction or power of such magistrate to cognizance. My lady, 54. Interpreting this provision, the two judges present of this court in Subramanian Swamy case held that neither can an FIR be filed nor can a direction be issued under Section 153(6)(3) CRPC, and it is only a complaint which will be instituted by a person aggrieved. My lady, may I pause here? Criminal defamation, which is part of the Kohima case. An FIR cannot institute a case of criminal defense, criminal defamation. A complaint has to be filed. Section 199 clearly says so. My lady, I'll be referring to the particular section afterwards, but an FIR will not lie. If anybody alleges criminal defamation, then that person, the aggrieved person, must go before a magistrate under Section 200 and file a complaint. It cannot be instituted through an FIR. And my lady, 55. In view of the clear legal position, Mr. Kipal Sipal, Learned Senior Counsel appearing on behalf of the state of Maharashtra, has fairly stated that the FIR which is under investigation, N.M. Joshi Marg Police Station in Mumbai, does not and cannot cover any alleged act of criminal defamation. We clearly clarify this in our final direction. We will clarify this in the final 57, right? 57. We hold that it would be inappropriate for the court to exercise its jurisdiction under Article 32 of the Constitution for the purpose of quashing the FIR number such under investigation and N.M. Joshi Police Station in Mumbai. My lady, this is the first FIR. They don't have the power because 482, 227 only. So, in adopting this view, we are guided by the fact that The check and balances to ensure the protection of the petitioner's liberty are governed by the CRPC. Despite the liberty being granted to the petitioner on such and such, it is an admitted position that the petitioner did not pursue available remedies in law, but sought instead to invoke jurisdiction of this court. Whether the allegation contained in the FIR do or do not make out any offences as alleged will not be decided in pursuance of this jurisdiction of this court under Article 32 to quash the FIR. Petitioner must be relegated to the pursuit of remedies available under CRPC, which we hereby do. The petitioner has an equally efficient remedy available before the High Court. We should not be construed as holding that petition under Article 32 is not maintainable. But when the High Court has the power under Section 482, there is no reason why pass the procedure under CRPC. We see no exceptional grounds or reasons to entertain this petition under 32. There's a clear distinction between maintainability of the petition where it should be entertained. My lord, that is not very important. My lady may kindly come to 59. As we have noted, multiple FIRs and complaints have been filed against the petitioner in several states and union territories of Jammu and Kashmir. By the interim order of this court, further steps in regards to all the complaints and FIRs, save and except for investigation of the FIR lodged at the police station, Sadar, Nagpur City, West State. The FIR at police station district, Nagpur City, has been transferred to NM Joshi Marg Police Station, Mumbai. We find merit in submission of Mr. Kipal, Learned Counsel, that fairness in the administration of criminal justice would warrant exercise of jurisdiction under Article 32 to quash all FIRs. However, we do so only having regards to the principles which have been laid down in the court by this court in T.T. Anthony. The filing of multiple FIR arising out of the same telegraphs and show hosted by the FIR petitioner is an abuse of the process and impermissible. We clarify that quashing of those FIR could not amount to expression of any opinion by this court on the merits of the FIR which was investigated by NM Joshi Marg Police Station, Mumbai. 60. We find no my lady, this is relating to another case, so this is not important. We just read this. We find no reasons to entertain the subsequent writ petition which has been filed by the petitioner in respect of FIR lodged in police station number such and such. The basis on which the jurisdiction of this court was invoked in the first petition, the filing of multiple FIR in various states, is absent in the subsequent writ petition. The petitioner could be at liberty to pursue his remedies under the law in respect of the FIR. Any recourse to such remedy shall be considered on its own merit by the competent court. Then, my lady, the direction. 61.2. Interim order of this court, there is such by which FIR number such and such was transferred from police station Sadar to Nagpur City to Joshi Marg Police Station, Mumbai, is confirmed. The FIR which was not being numbered as such shall be investigated by NM Joshi Marg Police Station in Mumbai. 61.3. We decline to entertain the prayer for quashing of FIR number 164 of 2020. That is the first FIR under Article 32 of the Constitution. The petitioner would be at liberty to pursue such remedy as available in law under the CRPC before the competent forum, and such application shall be considered on its merit by competent authority. 61.4. In view of the law laid down by this court in Subramani Swamy, we clarify that the above FIR does not cover the offence of criminal defamation under Section 499. My lady, no FIR will lie. Which offence will not form the subject matter of the investigation. Or the police can't even investigate relating to criminal defamation. Only through a complaint before the magistrate it can be instituted. Hence, it is not necessary to address the prayer for dealing with the 61.5. The following complaints were quashed following the direction of this decision of this court in T.T. Anthony's case. The successive FIR complaints founded on the same course of action are not maintainable. My lady?
Okay.
So, out of the same course of action. Now, 2010.
I think that will do as far as the principles are concerned.
Yes, my lady, I've given the same. Now, my lady, regarding all this, is arising out of the same course of action. Only one difference that I find is defamation. Otherwise,
Defamation and
because that relates to
use of logo.
Logo is out of the same course of action. That is selling of lottery tickets. Because Charge clearly says logo, using the logo in the lottery tickets. Charge has clearly mentioned that also. So that is out of the same course of action, selling fake lottery tickets. So, yes, my lady.
Okay.
So now, my lady, the only thing I find is that defamation. This is the only allegation that is distinct from what has been made in the Kolkata. That we have, but in the charge sheet, initially in the FI says stealing, stolen confidential
But that
documents.
section is not there.
But that this allegation is not there. So, my lady, first of all, if I obtain certain documents through RTI, Chashi says that I've obtained it through RTI, and I've used it to make frivolous complaint to competent authorities. Will it come within the ambit of 499? It will not. I take certain documents through RTI, I make complaints to the Prime Minister or to competent authorities regarding maybe even it's frivolous complaints. Let's see. Defamation, will it come? But even if it comes, can it be instituted through an FIR? No. Why no, my lady? We always see this. That's IPC. My lady, CIPC 199 only. IPC chapter
Give me IPC also. Yes.
my lady, 199 CRPC.
Prosecution for defamation.
Yes, my lord. No court shall take cognizance of an offence punishable under Chapter 21 of the IPC, except upon a complaint made by some persons aggrieved by the offence. Complaint, my lady. And complaint is clearly defined under Section 2D, which means allegation, orally or writing, made before the. There is already there. So FIR will not lie. 499, 500. So the only offense allegation which is different is out again. Cannot be a. No, man. The others are. That's my case, man. So all the rest allegations relates to the same cause of action. Even if my ladies, if the Honorable Court is being bothered by the use of the logo was used in the lottery tickets. So it's within the same cause of action, which has been, for which an FIS will file. There also we are under on bail. In that case also, my lady, we are on bail. And then investigation is going on. Now, if they think, no, we also need to impose their mega complaints further, all this can be said there, and this will be part of the investigation. That is what the law says, madam. Right.
Okay. Yes.
Your Lordship may fix it on the next date, Your Lordship, and the trial court records may be called for, Your Lordship. And then I will make my submissions on the next date, Your Lordship.
When can you come next?
Next, Your Lordship, any day Your Lordship fixes, Your Lordship. I'll do it.
This week?
This week, Your Lordship, it will be a bit difficult, Your Lordship. If next week, Your Lordship.
Oh, 9th then?
Yes, Your Lordship, I can come on 9th.
9th?
Yes.
The records are before CGM or GMFC? Which court? Which court?
CGM here, Kohima.
CGM Kohima.
My lady,
9th is okay.
my lady, 9th.
9th, 10th.
10th is at 9, 10, no. 12 will be okay. 12. Huh?
No. I don't want to go beyond that because this court is sitting only till 13th.
Till 13 only. 6 November now. 11 really good. 10 cheaper on 9th
or 10th would be more suitable.
My lady, it is not right, but trial matters with evidence is there, my lady. No option, 9 and 10.
11th?
11 is okay for me.
11th is DB day,
Wednesday.
but we can always fix it.
No problem.
12th, Your Lordship. Because it's a hearing date, Thursday, 12th.
No, I don't want to keep it till the end. Na?
Okay, Your Lordship, please.
So 11th would be okay. Heard Learned Counsel, Mr. M.T. Longjam for a petitioner, as well as Mr. Deori, no?
Yes, Your
Mr.
Lordship.
Deori,
Deori.
for the special PP for the state
Yeah.
response. So matter is part heard, list on 11 to 2026, on which date the learned special PP shall produce, or should I call from the...
Your Lordship may call for the trial court records.
Okay, stop. The registry is directed to call for the trial court records from the Court of Chief Judicial Magistrate, Kohima.
My lady, then
List on.
probably I was thinking of for making a interim protection, but since the record is called,
Record is called, so further
Yes.
proceedings will not be there.
my lady,
As a fixed item. No?
my lady, in case I am unable to make, I'll appear to online.
On 11th.
Uh,
Yes,
11th,
because your
something-
submission is over now.
Yes, Your Lordship. My Lord,
If some difficulties, my lord, then I'll appear to online.
I'm very grateful, Your Lordship.
I'll like, my lord.
Yes, you said updated case diary, no? Let's see.
Your Lordship, I just received the status report. The status report is that, Your Lordship, it is written that on 3 occasions, notice was sent, Your Lordship, for appearing before the IO. However, because of the non-appearance, Your Lordship, again, non-valuable warrant arrest was issued.
Was issued.
Yes, however, that could not be executed because the IO was on leave, and I could not even actually obtain it because he was on leave. So that is the only reason that the IO has actually stated it.
We have to cancel the interim then, in that case.
Lordship, that's
See,
subsequent.
the first interim order was granted on 6/11. 6/11. 6/11.
Lordship, I have no instruction as to whether the other notices were issued after this interim, because I'm yet to get any instruction from the client whether he has received any such notice.
Your Lordship, after the arrest of warrant is issued, Your Lordship, maybe after that, like the petitioner actually, the IO could not execute because he was on leave. So maybe an opportunity can be granted to him so he can appear before the IO.
We'll give a fixed date.
Yeah, fixed
Let
date,
him
yes.
appear. And after that, we'll see.
Yes.
Heard Learned Counsel for the petitioner, Mr. Moa Jamir, as well as Learned Public Prosecutor, Ms. Livika. Stop. Para. At the outset, the Learned Public Prosecutor has produced a copy of the updated case diary, wherein the IO has stated that three or two.
On 14th page, on the next page, notices are also on the.
That notices under section 179 BNSS dated 14/7/2025, 29/7/25 and 4/9/25 were sent to the permanent address of the petitioner, and the same was also intimated to his wife, Srimati Sunita Devi, through WhatsApp number 91990799870. But till date, the petitioner, Mr. Praveen Kumar, has not appeared before the investigating agency. Stop. Further, it is stated in the status report that the Honorable Session Court had also, the Honorable Chief Magistrate had also issued a non-bailable warrant of arrest against the accused, as the accused did not appear before the IO, even after sending 3 notices on 3 different dates. Stop. Para. Learned Counsel Mr. Mua Jamir submits that he has not received any instruction as to whether the petitioner had received these notices. Stop. And accordingly prays for another chance to appear before the IO. Stop. In view of the submission, the petitioner is directed to appear before the IO of the case on, when can you appear?
2 weeks.
On 17th February, on 17th February 2026 at 1 p.m. without fail, and thereafter record his statement.
Lordship, if interim may be extended to such time.
List on 19/12/2026. Appearance is 17th, na? Appearance is 17th, and this matter to be listed on 19/2, on which date the learned PP shall obtain the status report. The interim order passed earlier shall continue till the next date. Yes. Because in that criminal petition, inti bangjam, you put this also in the file. Done.